judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Because I was standing right next to the guy who fired the gun. It's a compelling case against this particular individual, and for those reasons, I ask that you affirm.
Thank you, Mr. Horn.
Thank you, Judge.
Thank you. Matter of Incorporated Village of Atlantic Beach against Zoning Board of Appeals of Hempstead and Sun Atlantic Partners. Mr. Shapiro, barring unforeseen circumstances, the last oral argument of the millennium.
Of the millennium. There'll be an emergency case next week, Judge. Judge Kaye, may it please the court, may I ask for 3 minutes of rebuttal if necessary?
Certainly.
In this case, Your Honor, we all know that zoning boards have a lot of power. We also know they have a lot of discretion. But there are limits. And we say this is the case where their power meets up with the limits of their power. And the core question that has to be answered is whether a prohibited use under a zoning ordinance can ever be an accessory use. Of course, our answer to that question is no, not as a matter of common sense and not as a matter of interpretation under this statute. To us, accessory use means something accompanying, going along with. And under respondent's theory, accompanying a use and something's prohibited, it's an oxymoron. They just clash. There's no way something that's prohibited can go along with something that's accepted.
Mr. Shapiro, are you going to address the mootness question since the use is gone? And the
mootness issue?
Yeah.
Yeah. I don't think we have a mootness problem here. As counsel concedes in the brief, the enclosure for which permission was granted was taken down because of some building code violation, not a zoning issue. So
for whatever reason it was taken down, it's gone, right?
So what we have here is a vested right. There's still a piece of paper from the zoning board which says to this landowner, you can use it, you can rebuild it tomorrow, you can sell it to somebody else because we know the rules in zoning. A zoning variance like this runs with the land. So if it runs with the land, they have a vested right to this use until some court sets aside this piece of paper. So, and of course, if they tried to rebuild it and we weren't in this court, I am sure that counsel for the landowner would run right into this court or start in the lower court and say, I have a vested right to that. I have a piece of paper. It runs with the land. You can't take that away from me. So I certainly don't think we have a mootness problem because the particular structure that was built under the authority was taken down because the authority still exists to put it back up tomorrow.
Is there anything in the record that indicates that that's going to happen?
Put it back up?
Yeah.
Nothing in there, but...
Well, wouldn't a determination of mootness here dismiss the action below and therefore vacate the order which granted the variance?
There's nothing really in the record, Judge, that says that it's been taken down. I mean, I'm not...
Well, I guess what I'm asking you to do is, are you, if we declare it moot, have you considered the ramifications of what the declaration of mootness here does vis-a-vis the appellate division order or the order at the Supreme Court? I
thought we suggested in our brief, a line of cases, that if it's moot, that it wipes off all the other cases along the way down, so it's not used as precedent for any other court.
It also would put a cloud on, I would think, a building permit to put it back up. I mean, it's very confusing as to whether the rule of law that would emanate from this case, apart from whether it would have precedential implications, and I gather it would from the way you open, whether it would have any legal effect with respect to these parties that is required to have a real case in controversy.
Well, if the court dismisses it as moot, and a week or two later they decide to put it back up, and then proceedings are brought one way or another in the lower court, then we tell the lower court, well, there's nothing There's nothing pending, so we start all over again. So the
We might
same.
be able to have the first case in the new millennium then. We could have this one to
That may
close
be.
and then another one to open. But it would be a different case.
It would be a different case, but the very same issue that we're arguing here today, whether the board has the power to do this, is going to be addressed in the next case in the lower court, and assumably work its way through the appellate division and back here.
So what if it's not moot, Mr. Shapiro?
If it's not moot, and we don't think it is, we think this ordinance is very clear. Earlier in my career, I was a town attorney, and I hope the court would agree the ordinance is clear. I would be thrilled if I had an assistant that would draft me an ordinance that reads this clearly. It says you have 2 uses allowed: a commercial beach club, no sleeping or lodging; a commercial bathing and swimming facility, no sleeping or lodging; and then we say accessory uses customarily incidental to, quote, any of the above permitted uses. I can't think of anything that would be clearer than writing it that way. Now,
Well, just to perhaps
obviously, Your Honor can
test that
think of a different
proposition, could that ordinance, the words of that ordinance, talk about overnight accommodations for guests? I mean, rather the purpose is not to turn these beach bathing facilities into beach hotels. And
Right.
couldn't one assume that was basically the underlying purpose of it and read it that narrowly, which would permit a lodging for a caretaker because you want to have somebody who is on the premises 24 hours a day to handle emergencies, et cetera, and as an accessory use?
you're saying, can it be read that way and
Yeah.
it wouldn't be irrational?
Would it be
I
irrational?
have to say yes. You can read it that way.
Okay.
The problem I have with reading it that way is twofold. First, I think it violates the rule of Raritan and the other cases, which say the courts will look at these statutes first and apply the language as written, unless that language leads to an absurd or irrational result. If that's the case, then we get into what counsel's arguing here, how we can read it a different way, as Your Honor suggests. But I don't see these words on their face leading to an irrational or an absurd result. So I say, as a matter of statutory construction under Raritan, you must read these words, and we don't get to that second question.
Well, in our cases, we have expressed quite a bit of deference to zoning authorities' interpretation of the ordinance which they're required to implement, haven't we?
Absolutely.
And this zoning board has interpreted this not to cover a lodging for a caretaker, right?
Yeah, but the problem that we have with that line of reasoning is that what counsel's here to get up and tell you to defend that interpretation, it's not the board's interpretation. It's counsel's interpretation. They've done a good job to come up with another interpretation. They claim it's the members-only interpretation, that restriction doesn't apply to caretakers. It only applies to the members of the club, not the owners of the club. And when the briefs first came in and I looked at that, I had to think, is that something I really have to worry about and respond to? But my next question was, where did that come from? It came from good lawyers thinking of how they were going to save this, but it didn't come from here in the record from the zoning board. The zoning board didn't say the statute doesn't, the ordinance does not apply. It only applies to owners and not members. The zoning board just said it's incidental, it's a caretaker, that kind of use is okay in our view. So we're challenging their view of it. To say if the legislative body, like we pointed out in our brief, City of Buffalo said, in their zones, no sleeping, no residential use, and they said, except for a caretaker, they could easily have done that. They could have said that in the Hempstead ordinance, said, except for a caretaker, take care of the property. Because the reason they gave was a valid reason. I can't dispute that. You want a caretaker there. What I'm suggesting is the ordinance didn't give them that kind of power. And it didn't also say members only. No sleeping or lodging by members. That would have been an easy way to get the legislative intent. They didn't say that either. So the arguments that you suggested, are plausible. But we're saying the way this ordinance is crafted, having 2 uses, no sleeping or lodging, doesn't give the zoning board the room to maneuver, and I don't think we owe them any deference because your cases say if it's irrational, And I think the second Supreme Court judge said it was an irrational holding. The first Supreme Court judge said it was contrary to statute. I think all your cases say if something is contrary to the statute, and I can't see how this bangs up against the statute any harder than this one does. It's the statute and this, they just don't mesh. No sleeping or lodging, but counsel says, but I have an exception. Now, if the zoning board would have come up with that exception and somehow rationalized the reasons we're hearing here today and maybe pick something out of the legislative history of the ordinance when they passed this 12 years ago, I'd have a lot tougher time.
So what's your theory as to why the appellate division went so wrong as you view it? I mean, if it's all so clear and it's all so straight and it couldn't have been done better, and you know, it makes me at least scratch my head a little, and maybe with your help I could figure out if they're so wrong and you're so right. You know, help me understand the mesh there as opposed to the banging.
The only thing I can think of is in page 97 of the record. The appellate division has this sentence, and I don't know where it came from. It's not supported by the record. The caretaker who has for many years lived in an apartment year-round attends to the maintenance of beach club facilities and property. There's no support for that in the record anyway. There is support for the word caretaker, and there was one mention of the word maintenance. There is no support for caretaker who has lived there for many years in the apartment. When I looked the other day to prepare for this argument, I went through every single page in this record, not there. I even went back to the Supreme Court briefs, which are not part of the record. The Landowners Council in one place used the words many, many years. Maybe that's information that she had when writing the briefs. I'm not faulting her, but it's not in the record. And if I have to guess, which is all I can do as to why the appellate division went that way, is that sentence was persuasive to somebody to say it's happened for a lot of years. You know, why are we going to cut it off now?
No, it was persuasive to 5, strong panel in the appellate division. That's why I pursued you a little bit, just to try to figure it out as to where they went wrong. And if that's the pivot, if that's your theory, that finding, let's call it,
that's the only thing I can think of, Judge, because that sticks out starkly because it is nowhere in the record. It may or may not be that this went on for a long period of time. I don't have any idea. But that's not in the record anywhere, and someone may have felt that the position of the board was sustainable because it had gone on for a period of time. But if this case was based on a non-conforming use theory, which it wasn't, and the applicant's attorney specifically wrote to the board on page 58 of the record, said, I don't want it considered under that theory. I just want it considered under a determined, an erroneous interpretation. So to answer your question as best I can, I think that sentence got somebody to the point where saying justice isn't being done by construing it this way. And I'll just close with this. This construction that we say flies in the face of the statute and the board has no power to do is not written in stone. It can be changed by the town board tomorrow, just having a meeting and giving notice and passing a new ordinance. And in the 2 years since the first Supreme Court judge gave this interpretation, we've seen no indication that the town board is unhappy with that interpretation, or they would have passed the statute. Then the case really would be moot, because I'd be dealing with that rule, and I don't think you'd let me say anything past that. So.
Thank you, Mr. Shapiro. Mr. McKevitt.
May it please the court. We have a situation here where you do have a beach club which does contain over 69,000 square feet. There are 400 lockers and cabanas. And when we really look at what the definition of the beach club is, as reflected in the ordinance, it is a place where people will go during the summer months. There's swimming pools, there's the beach, there's the cabanas, the bathing facilities, and that's what the purpose is of the beach club as what is allowed in the ordinance. And the ordinance states that in this beach club and swimming facilities and commercial or private beach club facilities, there shall be no lodging or sleeping. And that's what that prohibition simply applies to. When you look at the other portion of the ordinance, under 232.3, it then goes to the other portion dealing with accessory uses. I mean, even when you look at where it talks about permitted uses under 232.3, it talks about a building or structure may be erected, altered, or used, and a water premises may be used for that following purpose and no other. it talks about, again, the private or commercial beach clubs, the private and commercial bathing and swimming facilities. So by that definition of alone, what we're looking at here under the accessory uses is something which in its instance is not a permitted use. What the zoning board here has done then is look and see whether that this caretaker's residence is allowable as an accessory use. Is it customarily incidental to the beach club property? And when they're looking at all the evidence, which they're familiar with themselves, and they're saying that this is a place which is only occupied during the summer months, that it is a large facility, that it's open to vandalism because along the beachfront, anyone can just walk right along and come into the area, that this is a situation and a place where it is beneficial to the club to have their caretaker's residence.
Mr. McKevitt, is there indeed support in the record for the sentence, the caretaker who has for many years lived in the apartment year-round attends to the maintenance of the beach club facilities and property, and if so, where is it?
I believe it is, Your Honor. If you look at not only the letter, which is written to the zoning board council on page 58, but if we go to one couple pages beforehand to page 56, which is the memorandum from the Town of Hempstead Department of Buildings plan examiners. When the application originally is made to the building to go and do this extension, it must therefore first go to our building department. And the plan examiners, one of either architects or engineers or examiners, takes a look at it. And the basis for denying this application for having the enclosure of the sun deck is based upon the fact that this caretaker's residence was originally interpreted and not contradicted by anyone in this case as non-conforming use. This ordinance came into effect in 1987, and one thing that the ordinance does allow is any non-conforming uses. And what has been determined by the building department, and it isn't explicitly referenced as their evidence here, but there was apparent evidence of the knowledge of the department that in 1987, when this ordinance came into effect, this caretaker's residence had been there for that period. So now when we come now to 1997 and 1999, in the instance where we're now before this court, the rational interpretation of this is that, yes, he's been there for many years because originally the interpretation, which was being examined, was whether this was a non-conforming use, and no one was debating whether it was a non-conforming use. Clearly, no one is being able to contradict that this thing has been there since at least 1987, and maybe long before that.
Except that with regard to a non-conforming use, you can't increase the density of the use, right?
Correct.
So if it is indeed a non-conforming use, you can't build the deck.
That was the interpretation of the building department, that if this is non-conforming use, that if you go now enclose this apartment area on the second floor, that you've now increased the density of this use.
So indeed, if indeed the appellate division were using that to somehow garner a vote from somebody, that it runs directly afoul of the density restrictions of expanding non-conforming uses, doesn't it?
It follows the argument that was initially at point here, was originally the issue, is that this was non-conforming use, and whether, therefore, the density can be increased. What the zoning board, when they're looking at the decision, was able to say, well, we're not, although, and the zoning board decision as well, too, on page 44, they talk about the point that there is potential non-conforming use, but they're saying there are other reasons as well why this is permitted.
Doesn't the language seem fairly clear and understandable that private or commercial beach clubs, excluding day camps, no part of which shall be designed or used for lodging or sleeping? Doesn't that sound, I mean, it sounds to me, I see this language, it says, no part of which shall be designed or used for lodging or sleeping. Sounds to me like it doesn't matter why someone might lodge or sleep there. No part of the permitted use, the private or commercial beach club, is allowed to have an overnight stay.
And that's where I think in some extent there's somewhat of an ambiguity here as well. Because
what is the word that's ambiguous? The no?
When you look at the rest of the ordinance and you look at the accessory uses, that now we have accessory uses which are incidental to the permitted use being the private or commercial beach clubs,
if we were to agree with you, then indeed an accessory use could be something that normally would be incidental to a permitted use, notwithstanding a specific prohibition within the permitted use?
I'm not agreeable that it's necessarily a complete prohibition. The ordinance doesn't say there shall be no caretaker's residence whatsoever or no residence. We're talking about to the club facilities itself, and when you look and talk about the words about cabanas and lockers, there shall be no lodging or sleeping.
It says no part of which shall be designed or used. It doesn't say no part of the cabanas, no part of the bar, no part of, it says no part of which. Now, let me see if I understand. You're saying that, let's take the no part out for a second. Just says beach clubs. You say beach club, normal accessory use, have a caretaker. You need one because there's a lot of winter in Long Island, and you need somebody to keep an eye on things, right?
Correct.
Okay. And so, I'll give you that, it's accessory use. But now the municipality says no part of which shall be designed or used for lodging or sleeping. Seems to me like they're prohibiting lodging or sleeping from occurring within that use, aren't they?
Well, I think another reading you look into is exactly what is the beach club. You know, the beach club is something where members come in, again, they'll stay there during the summer, go bathe on the beach, bathe in the swimming pool. But what this facility we're talking about here is not something which is open to any member of the beach club.
If
it's
it
a
had
private
said,
facility for storage on the first floor and the caretaker's apartment on the second floor.
if it had said no part of which shall be used for lodging or sleeping, and there shall be no caretaker, you couldn't have an accessory use of a caretaker, right?
I would agree with that,
Even
yes.
though 99.9% of all the other beach clubs in the world have caretakers.
Because that's it, as board has found, that's certainly an accessory use.
So step one is that you have to be able to establish under the statute that that language does not preclude the accessory use, which is normal to, what you think is normal to a beach club, that being a caretaker.
Correct.
Okay.
Which is
All right.
incidental to the primary use.
Okay. That's right.
That's why I believe that our argument in a whole comes down to in that instance. And again, I believe that what the board has done here is they made their analysis based upon all the facts. And I think even looking at this court's determined New York Botanical Gardens and looking at the nature and character and the principle of the use and looking at the whole area and looking at the analysis, this is the basis which the board has made their determination. And I believe it rationally stands.
Thank you, Mr. McKevitt.
Thank you.
Ms. Insardi?
This is it. This is the last person.
With all due respect to counsel from the village, I wouldn't want this person drafting my statute. I'll tell you why. And I'm hearkening.
It's your last shot in the millennium.
It may be slightly boring, but back in grammar school, when we used to parse our sentences, we would be given sentences like this and have this subjunctive clause. So I would suggest to this court that the subjunctive clause here, no part of which relates back to private or commercial beach club, or in subsection B of that same statute, private or commercial bathing or swimming facilities. So I think that the statute is clear. I think that the reading that the village urges is overly restrictive and gets to an absurd consequence.
But Ms. Insardi, you have to start with a building or structure may be erected, altered, or used, and a lot or premises may be. So there are only two permissive uses to begin with. It can be either a beach club or a bathing or swimming facility. There's no other permitted use on the premises.
That's true. But I think the restriction, the prohibition for lodging and sleeping applies only to the commercial beach club. It does not, it is not meant to apply to a caretaker's residence.
But there's that's not a permitted use.
A caretaker's residence is not a permitted use, that's correct. It's an accessory use. It is a use that is
An accessory use.
incidental to the beach club.
No. It's incidental to any of the permitted uses.
Yes, and that permitted use is a beach club. And what I would suggest is that this board looked at the definition of accessory use and said, okay, we don't have restrictions on accessory use. The only restriction is they have to be on the same lot and customarily incidental to any of the above permitted uses. The permitted use is the commercial beach club, and a caretaker's apartment is allowable as an accessory use to a commercial beach club because that use is truly incidental to the beach club. It is beneficial, as Judge Wesley pointed out. There are many benefits to having that caretaker in an area that is deserted for long periods of time and subject to bad weather elements. And, you know, you could have people building bonfires on the beach, and there's really nobody around to see what is going on.
Does this have a ripple across the state, or is this kind of specific to you folks?
probably kind of specific to beachfront areas. And as you pointed out, you know, I think it's not uncommon to have caretakers' apartments in areas where they are deserted for large portions of the year. And I think that when you look at the statute as a whole, when you focus on other parts of the statute, for instance, the restriction on cabanas and section 232, bear with me.
By the way, if your fellow respondent is right, you could still keep your caretaker. You just can't build the deck, can you? Because it's a non-conforming use. I mean, you agree that it's a non-conforming use?
Yes.
It can be both. I didn't say it can't be.
Yeah. I didn't want the court to find out today that this thing had been taken down, so I was obligated to raise the issue and bring it to the court's attention. And
Are you putting it back up?
pardon me? I really don't know.
So you're not intending to expand your non-conforming use?
Not.
Doesn't sound like a real live controversy to me right now between you and the village, is it?
I think that the point that council makes is good in that it is a precedent that has been set by the board, and they have the right to.
Well, let's examine that just for a second. Let's talk about the procedural context of this. There's an application by you for the right to enclose it.
Yes.
Enclose that deck, correct?
Yes.
It's fairly specific to the activity you wish to engage in, correct?
Yes.
It was premised, it was ultimately approved by the Zoning Board of Appeals, right?
Yes.
On the premise that it was an accessory use.
Correct.
And so therefore, it was specific as to that deck because it was a permit as to the dimensions, size, et cetera, of that deck, correct?
Correct.
And it was premised on a law interpretation that the caretaker's use was an accessory use.
Yes, that's correct.
Right, which you also say is non-conforming and so therefore will be allowed to continue, correct?
The board specifically rejected that interpretation that it was a non-conforming use. The building department
The appellate
initially.
division.
Pardon me?
Okay, but you both agree that it's a non-conforming use.
It predated the statute.
Okay.
I don't know that that it would be a non-conforming use.
Is it your opinion that as a result of this case and without a resolution of this court that your rights are, that you're entitled at any time to rebuild the deck and to enclose it?
I believe that would be subject only to whatever limitations there are with respect to building permits.
If this matter were determined to be moot and the Article 78 dismissed such that the rights of the parties had not been determined in a court of law, would you still have the right to litigate this again, in your opinion?
Yes.
Okay.
If we look at the statute as a whole here, we have the restriction on cabanas, which is 232.4J, and that is very specific and detailed about restrictions on the design and furnishing of a cabana. And that is indicative of the fact that the prohibition against sleeping and lodging was explicitly aimed at the use of cabanas and not a caretaker's apartment. The second indicia that we have that this wasn't aimed at a caretaker's apartment is the legislative purpose, which is set forth, and that's in the statute, and it speaks of the unique, fragile nature of the oceanfront, and the case cited by Village Council, Clearwater, which says the goal here, they upheld the constitutionality of the enactment of that section pertaining to the Marine Recreation District because they wanted to prohibit residential development. Now, there's a big difference between residential development and a caretaker's apartment. And I think that the caretaker's apartment actually furthers the purpose of the legislative purpose because it helps to protect the unique and fragile nature of the oceanfront. And the third indicia that we have that it wasn't limited to, that the prohibition was not applicable, is the definition of accessory uses. And again, if you look at this section on accessory uses, any use, it really allows any use that fits within the statute. Obviously, it has to be reasonable, not arbitrary and capricious, but that statute includes language of inclusion rather than exclusion. So I think it's like the Exxon case, in that, you know, where the court, the first department in that case, said, board, you have to look at this definition, and you can't exclude a use when you have a statute that has language of inclusion. So the board given all of the above, made a determination, a fact-based determination, in accordance with Botanical Gardens, that the use, the accessory use, was truly incidental, did